I'd like to welcome next to the stage Brynn, who's a human rights advisor with the Australian Institute. So Brynn, please come up and we need to load your...
Yeah, it's on the same stick. So Shen's obviously spoken a lot about where we went to and how we kind of impacted this company and this system of contracts. And now I'm going to talk a little bit about how we're going to stick the knife in a little bit further in the coming months. So as Shen said, there's a company for OVR, which is really uncomfortable in the middle of this system now. One of their largest investors, one of their top 10 shareholders, is the Norwegian Sovereign Wealth Fund. Norwegian Sovereign Wealth Fund has a portfolio, has investments of over 1 trillion Australian dollars. They hold about 1.8% of all European stocks. So they're very, very large. So this is, I guess I'll speak a little bit about what the title is. The campaign, you're getting a bit of a sneak preview at a campaign the Australian Institute is about to launch called Dear Norway, where we, as Australians, ask Norwegian people to ask their pension fund to get out of our detention system. So I have the unenviable task, I think, a little bit of getting a little bit more technical. So I'm going to talk about this framework of business and human rights and how it can be used as a tool to achieve social outcomes. Divestment or exit of relationships is specifically contemplated by this framework, which is why I think it's useful. There aren't very many international policy and legal frameworks that specifically contemplate companies ending relationships with other companies. I'll talk a little about the corporate responsibility to respect human rights, which is emerging as an international norm, and then we'll talk about the Norwegian pension fund, but the first bit's going to be a little technical. So again, just to recap, we have the companies. So Broad Spectrum, formerly Transfield Services, lead contractor for both centres, was acquired by Ferrovial, Spanish-listed multinational, earlier this year. The Norwegian pension fund was one of the largest shareholders in Ferrovial, previously divested from Broad Spectrum. So No Business and Abuse published its first major report in October 2015. After that date, but before the end of the year, the Norwegian pension fund divested their shareholding in Broad Spectrum. So we have a sovereign wealth fund that has read a report that outlines a company's involvement in massive human rights abuses. That sovereign wealth fund chooses to divest. Now, they won't say why they chose to divest, and I'll get to that a bit later. That's quite unusual in itself, but they did divest. They have confirmed that they divested in that period of time. And as far as we're aware, they then, through their shareholding, their pre-existing shareholding, ended up associated with this system that they divested from previously. So we think they're a fairly good candidate for further divestment. So why did we adopt this business and human rights strategy? So again, this is one of the components of that very large strategy that Shen outlined. There were a whole range of sort of mini campaigns going on under this one very big No Business in Abuse campaign. But we used business and human rights, and by business and human rights, I'm talking specifically about the UN Guiding Principles on Business and Human Rights, which is a document adopted by the UN General Assembly the Human Rights Council in 2011, unanimously adopted. And we used it because it's it gives us a language to talk to companies. So once we'd gone through and done this huge mapping process of the companies and the company in the centre and all of their various stakeholders, we could see that a lot of those stakeholders, the clients of the company, particularly where those clients were corporations, BHP and Rio Tinto and so on, as well as the financiers of that company and the owners of that company, the investors in that company, were all subject to this particular framework, and we thought we'd give it a go, essentially, and Shen confirmed that a lot of this was a big experiment. So we used it because it's a common language, and because it's a really kind of nascent field, a field in development, we had a lot of room to move with it. And so we could essentially provide an interpretation of what we thought was the appropriate action for a company to take under this framework. And at least within the Australian private sector, the financial sector, knowledge of this framework is relatively low. Technical knowledge of the framework is relatively low, but the appetite for sort of leading on it is relatively high. So we were able to take advantage of that. So we use the UN Guiding Principles, which are supplemented by the OECD guidelines, which apply to all companies headquartered in OECD jurisdictions. And then and these principles, these fundamental principles about corporate responsibility to respect human rights, are often incorporated into corporate codes. So it may surprise you to hear that Broad Spectrum has a corporate code about human rights, and they say they have zero tolerance for abuses of human rights. We thought we'd try to hold them to account. So what's the responsibility of companies? How is this talked about in the international framework? And I will again apologise for how deeply boring this part of it is, but the reason that I'm labouring it is it really was a critical tool for us. And if we're talking about divestment, and if we're talking about ending finance relationships, asking companies to call loans, asking banks to call loans, then we need to be able to use this language. So, Guiding Principle 13, the corporate responsibility to respect human rights requires that business enterprises do two things. So it splits it out into two types of relationships to a human rights abuse. So if a business is causing or contributing to adverse human rights impacts through their own activities, then they should avoid doing that and they should address them. But then the more interesting one is 13B. Business enterprises should seek to prevent or mitigate adverse human rights impacts that are directly linked to their operations, products or services by their business relationships, even if they've not contributed to those impacts. And that's where you get an investor or a financier. Basically, in a whole lot of complicated and ambiguous language, this principle says that the responsibility to respect human rights goes through the entire value chain, that a financier has a responsibility for the human rights impacts of the company that it finances. So Westpac has a responsibility to at least to care about and to ensure that human rights are respected in the activities of companies like Broad Spectrum or Transfield or Ferrovial. So Shen and I, we wheeled these slides into a whole heap of boardrooms and sort of bored people to death with this stuff, but it got there. So, and then what do you do if you find you've got a responsibility? And this is where the exit comes in. So basically, once a company identifies that it is either causing or contributing to a human rights impact, a negative human rights impact, or it is directly linked somehow through its value chain to a human rights impact, then the guiding principles say, well, you've got to take appropriate action. What is appropriate action? Well, and it kind of suggests a few things. It says that it varies. Appropriate action could mean a variety of different things. And this is where the commentary to the guiding principles, and again, I absolutely apologise and disclaim this horrible piece of text, but there are situations in which the enterprise lacks the leverage to prevent or mitigate the adverse impact. So there's a situation in which a bank has no leverage over the company that it is financing and these activities that it's financing, and the bank, the only thing it can do is to call a loan. The only thing it can do is to exit the relationship. So this is where, in the guiding principles, exit is specifically contemplated. Credible enterprises should consider ending the relationship. Okay, so that's basically where we went. So the Norwegian pension fund again, over 1 trillion Australian dollars, 8 trillion Norwegian kroner, 1.78 of all European funds, has some very strong codes. They have a human rights expectations document, they have a children rights expectations document, as Shen already stated. The evidence of breaches of all international laws relating to human rights, or very, very serious breaches of international law relating to human rights, is incontrovertible, is overwhelming. It has only gotten more overwhelming in the last 12 months. The unusual thing about Norway, or the Norwegian pension fund, is that because it's a sovereign wealth fund, it's the people's money, the money of the people of Norway. And the people of Norway, it turns out, have an interest in and a stake in the behaviour of this fund. There's a lot of press interest in the fund's activities in Norway. Then what they have is guidelines for the observation and exclusion of companies. The Norwegian pension fund publishes a list. It excludes companies on two bases. One is the conduct of the company. There is evidence that this company has been involved in something very bad, and we have seen that evidence and we have reviewed it and we've consulted the company about it, and we're not satisfied that they're doing anything about it. So we'll put them on this big bad list. And so we will be making an argument that there is evidence that Ferrovial has been involved in very bad conduct, and we'll be asking the Norwegian pension fund to publish their reasons for divestment. If they divest, then to publish. And when I say it's very, very interesting that they didn't publish their reasons for divesting from broad spectrum, that's a departure from usual practice. So we've been in touch with people in Norway, previous members of the Ethics Council of the fund, and they have indicated that that's very unusual. So perhaps it's getting more conservative at that end as well. And then the other way that the fund can make an exclusion decision is to follow its guidelines about specific types of activities, sectors or products that it won't invest in. So one of those sectors is tobacco. One is there's a new exclusion around companies with a certain proportion of their revenue from fossil fuels. So perhaps in the second panel we'll have some conversation about that. And what we will be recommending to the Norwegian Ministry of Finance is that they adopt a new exclusion based on companies that operate detention facilities that fail to meet minimum human rights standards. So this is where I'll leave it, and this is where we're going in the next couple of weeks. We'll be publishing a report which outlines all of these relationships. Then we'll be asking Australians to sign an open letter to the Norwegian public. The letter will be presented to the Norwegian public through social media and a short video explaining all of these relationships. And people will be directed to a website that allows Norwegians to generate an email or a petition to their fund. And obviously the outcome that we hope to achieve is that the pension fund publicly divests. As Shen said, divestment really isn't the ultimate outcome. The outcome is making sure that the reputable private sector doesn't do this work anymore, and restricting the Australian government's access to contract partners to do this work. But divestment of such a significant actor would be a bit of a bomb to throw at the system at this point, if it is a public divestment. So I'll leave it there, but thank you, and thank you for bearing with me on the guiding principles. I hate them more than you do.
Thanks so much. Thanks very much, Brynn O'Brien from the Australian Institute.